So we will proceed to the 1 o'clock zoning appeals docket. So, good afternoon, everybody, and welcome to the August 2nd docket for the BMZA. Thank you for finding us in our new room. This is the first time we're holding hearings in this room, so if it was a little confusing, I apologize. We're glad you're here. My name is Becky Witt, and I am the assistant counsel to the BMZA. To my left is Tyler Morrison, who's filling in to help take notes today from the Housing Department legal section. And then we have, going from my right over, we have Sabrina Johnson-Turner, Bill Cunningham, James Fields, who's the board member and also the chair, and Leland Shelton and Otis Freeman. We have our court reporter over here. If you haven't already, please silence your cell phones. If you need to have a private conversation with someone, please do it out in the lobby area. When it's your turn to speak, you'll need to be sworn in if you're going to testify. Also, please sign in on the sign-in sheet if you're going to speak today, whether you are the applicant or an attorney or opposition or support. If you plan to speak today, please sign in so that we know you're here. The vote that the board takes today doesn't make the case final. We have to issue a written resolution. Generally speaking, those get sent out within 30 days. If you haven't heard from us after 30 days, feel free to reach out. And I think that's it. I'll turn it over. Well, actually, did we want to go through the docket and see which ones are which? Yes, okay. And then actually we have someone who wants to speak first before we get into all of our cases. I keep forgetting that. Okay, hold on 1 second. Okay, so just going through the docket in order. 2022-151 is on the contested docket or regular docket. 2022-232 is also uncontested. There's opposition here today. 2022-235 is on consent. 2022-238 is on contested. 2022-239 is on consent. 2022-241 is on consent. 2022-242 is on consent. 2022-243 is on consent. 2022-244 is on consent. 2022-245 is uncontested. 2022-246 is on consent. 2022-248 is on consent. 2022-249 is on consent. 2022-251 is on consent. 2022-254 is on consent. 2022-265 is on consent. And 2022-276 is also on consent, as far as I know. Okay, with that said, I guess I will introduce Mr. Ted Carter, who wanted to make some comments. And turn on the mic.
Okay. Good afternoon, Chair Fields, members of the board. My name is Ted Carter. I'm the Deputy Mayor for Community and Economic Development for Mayor Scott. Pleased to be here today. This is my first time before this body. I've been here 15 months, and while I oversee 14 agencies, including the Department of Planning and Housing Community Development, while this is the smallest of the 14 agencies, arguably one of the most important, so look forward to spending more time with you going forward. On behalf of Mayor Scott, wanted to start by thanking each of you for your incredible commitment to building our city. The role you play is just so important to the mayor's agenda around equitable neighborhood development. And so the time that you put into this effort, your care and concern and love for our city is evident. So I just wanted to start by thanking you. Also wanted to announce that with the departure of Ms. Byrne, that Rebecca Witt will be the acting director. We have initiated a hiring process and expect to move expeditiously to fill this role on a permanent basis. Also want to just take a moment to acknowledge Ms. Burns' work, who was performing this job in two roles, both as an assistant commissioner for the Department of Housing and Community Development and also the acting director of this body. In the time that I've been here, really was very moved by her passion and commitment to our equity agenda, to development of the city, and carrying two roles is challenging, and you'll have that opportunity. So we're here to support Ms. Witt while she's acting. But just wanted to acknowledge her work and contributions to the city, to supporting your efforts, which are volunteers. She was obviously an employee. So just wanted to come by and say thank you. I look forward to meeting each of you individually, whom I haven't met, and just wanted to give you that update on our personnel process. Happy to take any questions briefly, and I'll be here for part of the hearing.
Thanks for coming, sir. We appreciate it. And, happy to help any way we can continue to do so. Keep moving the city forward.
Okay, thank you, Chair.
All right, you can move forward with the docket now.
Okay. Well, again, thank you and welcome all for this session of the BMZA. We don't have any, doesn't look like any postponements on the docket today. But as you know, we are divided into a consent docket and a contested docket, as Ms. Witt just informed you. Those cases that are on the consent docket are cases that we believe, that the board believes it has sufficient information to approve the appeal. So it's a very efficient resolution. When your case is called, you'll come up and podium's in a different place than it usually is in the Board of Estimates room. So I guess you can line up in one behind the other, and we'll call your case. We'll hear reports from planning and staff. Then we'll resolve your matter, and we'll keep that moving. On the other side, those matters that are contested, it's just like in court. We'll have the appellant or the applicant proceed first with their presentation. Opposition will have an opportunity to then be heard, and then the appellant has the final word. We will endeavor to deliberate immediately after your matter and render a decision. Unless we find that there's some information that we need, some additional documents or information that we've requested, or for any other reason that it appears to the board more prudent to spend a little more time deliberating, and we will identify when we will conduct that deliberation and conclude and give a decision. We'll also say that with regard to your matters, if you are unable to stay to hear the result of those contested matters, you may contact the zoning board. I guess that 410-396-4301. I've said that so many times, I should remember that, right? So you can call that number, find out the ruling that's been rendered on your matter, but we ask that you take no action toward your project until you've gotten that decision, and certainly refrain from doing any work within Baltimore City without pulling the proper permits. And with that, we'll commence with the consent docket, and I'll call those cases, and again, you can line up in the order in which the cases have been called, and then we'll hear your matters. Case number 2022-235, 3305 7 Mile Lane, Donnie Ancree is the appellant. Case number 2022-239, 2318 Essex Street, Pete Weinberg. 2022-241, 2200 Poplar Grove Street, Olalekan Okatunji. Okay. 2022-242, 5111 Plainfield Avenue, Atia Wells. 2022-243, 1212 Haverhill Road, Jeff Landau. 2022-244, 6077 Harford Road, R&H Community Services. Case number 2022-246, 3123 West North Avenue, Eric Thompson Bay. Case number 2022-248, 1800 Light Street, Alex Trackman. 2022-249, 5603 through 5607 North Charles, Mark Schroeder. 2022-251, 4035 Falls Road, Ward and Company is the appellant. 2022-254, 3200 Gwynns Falls Parkway, Paula Richardson. 2022-265, 5820 York Road, Yvonne Arthur. And finally, 2022-276, 801 South Ann Street, Stephen Fogelman. Could we have all those that are here for the consent docket raise their hands and be sworn?
You swear or affirm by the penalty of perjury, testimony about to give will be the truth.
Thank you so much. Case number 2022-235, 3305 7 Mile Lane. Mr. Ackley not here? Okay, sir, you are?
Yes, my name is Gabriel Monfort. I work for the Oh, I apologize. My name is Gabriel Versiani Manfra. I work for Donny Acre Architects.
All right, gonna need you to spell your last name.
Versiani,Versiani, space Mafra.
Yeah, I'm going to ask you to slow down a little bit on the microphone because it's a little bit struggle. Again, part of it is this new system, and we've got to train our ears to hear.
Push the button so the ring stays green. Yeah.
All right.
And just let it stay green, and we'll hear you. All right. This matter addresses variances to bulk regulations regarding the construction of a two-story addition. Is that correct?
Correct.
All right. I'll hear from planning and staff, or staff and planning. However you want to look at it.
I'll go first. So the variances that have been requested are a minimum front yard setback, 30 feet is required, 23 feet is proposed, so it's a 7-foot variance. And a minimum interior side yard setback, 10 feet is required, 3 feet is proposed, so it's a 7-foot variance. There is a letter of support from Cross Country Improvement Association in the file.
Martin French for the Baltimore City Planning Department. The Planning Department has no comment on this application. Thank you.
Thank you, Mr. French. Sir, is there anything you'd like to add to your application at this time?
Not really, unless there's any further questions.
Okay. No questions from the board? The board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
Thank you.
Case number 2022-239, 2318 Essex Street. I have Pete Weinberg as the appellant. I see someone else. Mr. Prettle, welcome. This matter addresses variance to bulk regulations to construct a 3-story rear addition and a rooftop deck. Is that correct?
That's correct.
All right. I'll hear from planning and staff.
So 2 variances here, minimum rear yard setback, 20 feet is required, 3 feet is proposed, so it's a 17-foot variance. And maximum lot coverage, 80% is allowed, 95% proposed, so it's a 15% variance requested.
Planning Department has no comment on this application. Thank you.
Mr. Pearl, is there anything you'd like to add to your application at this time, sir?
Not at this time.
Very well. Board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you.
Thank you. Case number 2022-241, 2200 Poplar Grove Street. And I apologize if I mispronounce your name, sir. Olalekan Okatunji?
That's fine.
All right, sir. This matter seeks to use a multifamily dwelling consisting of 2 dwelling units.
Yes.
Correct? Reports from planning, staff and planning, please.
So the request here is to affirm the existing multifamily dwelling use with 2 dwelling units. We have the last authorized use of the property is for 2 dwelling units. So it's basically just a request to use it as the last use already says it was.
Thank you.
Oh, sorry.
Thank you. Planning Department has reviewed this application, has no objection to its approval, recommends if the board determines to approve it, that the approval include the condition that the property complies with the terms and conditions of the Baltimore City Code, Article 23, which is the sanitation code. Thank you.
Okay. And sir, are you Satisfied with that condition?
Yes.
All right. Is there anything you'd like to add to your application at this time?
Yes, there was a fence I was trying to add at the rear of the house that, encloses the side steps that, put an application through right away. They said I should come back to zoning. I tried to write in the amendment on my application. I was trying to see, is this the right venue for that, or how do I go about that?
So you would probably have to submit plans to, in room 147 for the fence, and that would be a separate application that would have to come back to us probably if the fence is higher or in a different place than is allowed by the code. So basically I'm saying, you can follow up with me later, but probably you have to submit a second application for the fence.
Who do I follow with? You said follow up with you?
Yeah, or you can send an email to bmza@baltimorecity.gov.
Got it. That's it.
All right, sir. That having been said, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you so much. Case number 2022-242, 5111 Plainfield Avenue. Tia Wells. Anyone here? Ms. Wells, 5111 Plainfield. All right, we'll move that to the end. Case number 2022-243, 1212 Haverhill Road. Jeff Landau. All right. Come on up, sir. Are you Mr. Landau?
Yes,
All right, sir. This matter addresses variances to bulk regulations to install a 6-foot fence along Clarendell Road on the right side of the property. Is that correct?
correct.
All right. I'll hear from staff and planning.
So this is a minimum corner side yard setback. 20 feet is required, 0 feet is proposed, so it's a 20-foot variance requested.
Planning Department has no comment on this application. Thank you.
Mr. Landau, is there anything you'd like to add to your application at this time, sir?
No.
All right. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
All right, thank you.
Case number 2022-244, 6077 Harford Road, R&H Community Services.
Good afternoon.
Good afternoon.
I'm Tanika Rice. I'm here on behalf of R&H Community Services.
All right, I'm going to ask you, just keep your voice up, ma'am. I have a little difficulty hearing you. Your name again?
Tanika Rice, R-I-C-E.
All right. And this application seeks to use a portion of the premises as a driver's education classroom?
Correct.
Very well. Reports from staff and planning, please.
So this is a conditional use request for educational facility, commercial, vocational. One thing I wanted to point out is that there wasn't any parking information provided in the original application. And so it looks like you might need 2 off-street parking spaces. Otherwise, you would need a parking variance for the 2 spaces. So can you tell the board, I guess maybe after Martin gives his presentation, how many parking spaces are set aside for your property or for your business, if any?
Okay.
Thank you. Planning Department reviewed this application, noted that this property is improved with a building, but it also has a paved parking area in the rear of the property. That pavement, however, is not striped, so there's no way to count parking spaces. And there was no plan included with this application that showed the layout of the parking lot and the spaces that would be reserved for the proposed use. The department has no particular comment on the application, but would request that the applicant provide the board with information about the off-street parking that would be provided to support this use. Thank you.
Thank you, Mr. French. Ms. Rice, any information you provide us with regard to the parking situation?
Absolutely. So an additional plan was submitted to really lay out the grounds of the premises. It would be a theory-only education program. So there would be no on-street, no cars are required. So we would only be doing theory education for driving improvement. There would be no need for vehicles. However, there is ample parking spaces, public free parking on the streets for those who would seek services there.
Okay.
Okay, so in that case, we would also, because of the use, we would also need to approve an off-street parking variance for 2 spaces if there's no off-street parking provided, which we can just add right now.
Okay.
Okay. Any objection by the board to adding that variance, off-street parking variance? All right. Okay. Ms. Rice, is there anything else you'd like to add to your application at this time?
Not at this time, thank you.
All right. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
Case number 2022-246, 3123 West North Avenue, Eric Thompson Bay. Mr. Thompson Bay,
Yes,
how are you, sir? This is a request to use the premises as a community center, is that correct?
yes, sir.
All right. I'll hear from staff and planning.
So there's just the request to use the premises as a community center, which is a conditional use. I will note that in the zoning code, the off-street parking requirements, we ran into this last time, have to do with the fire rated capacity, which we cannot know until after we have this hearing. Maybe the city council should change this section of the code so that we can actually calculate based on square footage for this use, but we can't right now. So, so there's no way to know what the off-street parking requirement will be. They may have to return for an off-street parking variance because it looks like there's no parking available on site.
Mr. French?
Yes, Planning Department reviewed this application, and as your staff has indicated, we basically arrived at the same conclusion, and that was that because there was no information about days and hours of operation and the number of people who might be present for community events, it was not possible to indicate what parking variance might be needed under the zoning code. The department has no comment on the application otherwise. Thank you.
Okay, Mr. Thompson Bay, you understand we'll need that additional information in order to provide any parking variances, okay?
You just need to know, like, the capacity.
We need to know the fire rated capacity. So from the fire department, we need to know what the capacity of the building is. And that's usually something that you don't find out until after you've gone through the zoning process.
Right, yeah, that's what they told me, come here first.
That's just the way it's written in the code, so we can't kind of guesstimate how much parking the variance would be. So you may need to come back and submit another application for an off-street parking variance.
All right.
So when they'll notify me whether I need to do that? Or,
Well, once you get that information from the fire department as to the capacity, you would provide that information to
Okay.
the MZA. And to the extent that requires an off-street parking variance,
okay.
then you would need to come back and file a new application.
So just so I'm clear, continue to move forward
Yes, sir.
with what I'm doing so the fire department can come out.
Exactly.
Okay,
Exactly.
okay, sounds good.
All right. And is there anything else you'd like to add to your application at this time?
No, just appreciate it. That community center in my neighborhood is well needed, so I appreciate y'all, considering it, because it's well needed in this climate.
Okay. Awesome. All right. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal.
All right,
Thank you
thank
so
you.
much. Good luck to you, sir. Case number 2022-248, 1800 Light Street. Alex Trackman. Good afternoon. You're Mr. Trackman?
Yes, sir.
All right, welcome. This is a request to change the use from 2 dwelling units to 4 dwelling units. Is that correct?
Yes, sir.
All right. Let me hear from staff and planning.
All right, so 2 variances are requested. Minimum lot area, 2,625 feet of lot area is required. 1,920 square feet exists, so it would be a 705 square foot variance. Off-street parking, because they're applying to go from 2 units existing to 4, there would be 2 parking spaces required. I believe 0 are proposed, so that would be a 2-space variance requested. The last authorized use of this property is as a multifamily dwelling with 2 dwelling units.
Thank you. Planning Department has reviewed this application, has no comment, but recommends that the board, if approving it, make the approval conditional on the operation of the property, subject to the condition of complying with terms and conditions of the Baltimore City Code, Article 23, which is the sanitation code. Thank you.
Mr. Trackman, are you comfortable complying with that condition?
Yes, sir.
Regarding the sanitation code? Okay. Is there anything else you'd like to add to your application at this time?
No, thank you.
All right. The board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you.
sir.
Appreciate it.
All righty, good luck to you. Case number 2022-249, 5603 through 5607 North Charles. Mark Schroeder.
I'm a stand-in
Okay.
for Mark Schroeder. My name is Tom Spies, P-I-E-S.
Okay, Mr. Spees, thank you so much. Uh, This is a request to use an empty dwelling as a temporary classroom space for 1 school year. Is that correct?
That is correct.
All right. I'll hear from staff and planning.
So this is a conditional use, educational facility, primary and secondary. Mr. Schroeder and I had an email conversation about off-street parking, and they have sufficient parking, so no off-street parking variance is needed.
Thank you. Planning Department has reviewed this application and has no objection to it. Thank you.
Thank you, Mr. French. Mr. Spees, is there anything else you'd like to add to your application at this time, sir?
No, we're looking forward to expanding the school.
What school is it?
It's associated with the Church of the Redeemer, and this is a 2nd grade, so we already have them enrolled, so I'm glad this got approved.
Great.
So we're at 15 to 16 kids, this starting in September. The yellow buses will show up on time, so this is important, so.
Excellent. Well, Mr. Spees, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very much.
Appreciate your work.
Appreciate it.
Thank you. Case number 2022-251, 4035 Falls Road. Ward and Company is the appellant. And
Kathleen Ward, W-A-R-D, attorney for the property owners, Ms. McWilliams and Mr. A.G.
Very well. And this is a request to use the premises as offices. Is that correct?
That's correct.
All right. I'll hear from staff and planning.
So, right, this is a conditional use to use the property as an office on the ground floor and upper floors in a residential mixed-use zoning district.
Thank you. Planning Department reviewed this application, is recommending approval. Notes, however, for the applicant's benefit, that the zoning code requires that the upper floors of the structure may be used for offices related to the ground floor business, as long as the upper floors are not open to the general public. Subject to that specific condition, the department recommends approval. Thank you.
All right. Thank you, Mr. French. Ms. Ward, is there any, you agree to accept that condition?
The applicant understands the requirements of the code provision.
All right. Is there anything else you'd like to add to your application at this time?
No, not at this time. Attorneys could take up a lot of your time, but I'll step back.
All right, we appreciate that. The board having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
Thank you very much.
Case number 2022-254, 3200 Winds Falls Parkway. Paula Richardson.
Yes,
You, sir?
Travis Howell, standing for Ms. Paula Richardson.
I'm sorry. Your name?
Travis Howell?
Travis Howell?
Yes.
Okay. You spell your name for the reporter?
My whole name or last name?
Your last name is fine.
Howell.
All right. And this is a request to use the premises as 2 dwelling units. Is that correct?
Yes.
We'll hear from staff and planning.
So this is another affirmation of an existing 2-dwelling unit multifamily use. There is a support letter from the Hamlin Improvement Association in the file, and they say they support the petition for use as a duplex. This request is consistent with the history of its use and occupancy and conforms with the several duplex dwellings in the 3200 block of Gwynns Falls. We have met with the owner and look forward to reviewing his plans and further introducing him to our association and community. And then the BMCA does have a land use card in the file as well that shows a history of 2 dwelling units.
Planning Department reviewed this application, noted, as you just heard, that this property has a record of use as a multifamily dwelling containing 2 dwelling units and has no objection to its approval. Thank you.
Mr. Howell, is there anything you'd like to add to your application at this time, sir?
No, sir.
All right. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Okay, thank you.
Case number 2022-265, 5820 York Road, Yvonne Arthur. Good afternoon, ma'am. Are you Ms.
Good
Arthur?
afternoon. Yes, sir.
Okay. This is a request to use suite number 203 as a driving school. Is that correct?
Yes, sir.
All right. I'll hear from staff and planning.
So again, this is similar to the Harford Road one that you just heard. This will be a conditional use for educational facility, commercial, vocational. And I'll just add the same thing about parking. We had an email conversation and the applicant told us that she will have 1 employee and 20 students, which corresponds to 2 required parking spaces. The business has its own parking lot, but we don't know exactly how many spaces are in that parking lot, so we need to know that today. And that is the end of my.
Planning Department reviewed this application, noted the same issue, which is that there is a large, and in this case striped parking lot, paved area behind this building. The applicant should indicate to the board how many parking spaces in that lot would be reserved for the proposed use. Subject to that, the department has no further comment. Thank you.
Thank you, Mr. French. Ms. Arthur, is there anything you can tell us about the parking situation?
The parkings are adequate. They have, anytime I go there, I notice there's a lot of spaces available. They have other tenants, and there's more spaces than there are tenants. But I can get back with you from the owner as to the number of parking spaces.
Okay. Does that information be helpful to you, Ms. Whit?
I think what the board require, or what the code requires, excuse me, is, so it sounds like there isn't a number of parking spaces that are officially reserved to you in your lease agreement or anything like that? Right, so your clients can just park wherever there's space?
They are dropped off.
Okay. Okay, so in the lease agreement that you have with the owner of the property, is there any information about parking and who's allowed to use it and whether some is reserved for certain people?
The only thing he stipulated is we don't use the parking lot for practicing
Okay,
parking with the students.
okay. All right, I mean, if there were no parking on site, we would have to give a 2-space variance. It sounds like there's plenty of parking on site, certainly for the 2 cars that are required. I think it's up to the board whether or not that information is sufficient or whether you want to give her a 2-space variance since there's nothing that's specifically set aside.
Yeah, so there's a parking lot, so long as it's not used to do the driving services, you're able to use the parking spaces, correct?
Yes.
All right. I'm fine with that. Okay, sounds like we're satisfied. All right.
Thank you.
Anything else you'd like to add to your application? at
No,
this time?
thank you.
All right, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very much. Have a nice day.
You too, Mayor. 2022-276, 801 South Ann Street. Stephen Fogelman is the appellant, and Mr. Berry is standing here for Mr. Fogelman. Sir, this is a request to use the first floor as a restaurant with beer, wine, and liquor license, BMZ 2015-355. That was a prior matter for that liquor license. To use the second and third floor as restaurant with beer, wine, and liquor license, and a variance required for off-street parking. Is that correct, Mr. Berry?
That's correct.
All right. Hear from staff and planning.
All right, so there's a conditional use being requested, expanding the existing restaurant to the second and third floors. Fells Point Residents Association submitted a letter with conditions that they say that the owner has agreed to, and that's probably true, so I'll just read those into the record, and Mr. Berry can agree to them or not. Here are the conditions. The second floor will be for dining and kitchen only. There'll be tables and a small private event space. There will be no bar or bar area on the second floor. Third floor will be used for storage only. No live entertainment, no outdoor speakers. The parklet that is currently occupied by flower pots will be cleared for parking until the restaurant is opened. Should parklets still be allowed by the city, the parklet can be reestablished according to the guidelines and permit process in place at that time. The restaurant will close at midnight for the first year of operation. And the owners commit to never staying open until 2 a.m. at any time in the future. Garbage will be picked up daily. And I also wanted to note for the board's information that there is an existing restaurant use that was the board granted under a different set of conditions, and wanted to see if Mr. Berry agrees that those existing conditions will carry forward as well.
Mr. Barry, Al Barry, AV Associates for the owner. We also have representative of the owner here. The conditions that the Fells Point Association recommended, we do not have any problem with, except that we believe that the hours of operation are more appropriately set by the liquor board. And so those have been in discussions between the community. It was our understanding when we agreed to them that the liquor board would memorialize those in its approval, and that if we had to come back to amend it, we would go back to the liquor board, which is typically the case, I think, in terms of these zoning appeals. I can't speak to the previous conditions. If you could.
I can read them now. I've just looked them up. Here are the previous conditions. This is from a 2015 case. All outdoor table service shall conclude by 9 p.m. daily. All tables shall be removed from the public sidewalk and stored inside the establishment when not in use. Standing use of tables is not permitted. A minimum of 6 feet of sidewalk must remain clear and unobstructed for pedestrian use. The capacity of the outdoor seating area will not be more than 5 tables and 10 patrons. The tables will be limited to those that can seat 2 patrons or are to be kept against the wall of the building. No outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by waitstaff. That's the existing set of conditions.
So those conditions were from the previous operator. The restaurant was known as the Wharf Rat. Some of you may be familiar with it. The new owner has negotiated a new set of conditions, which are reflected in the new agreement. Other than we would ask the board to defer the hours of operation to the liquor board, which I think is a reasonable request on our part.
Okay. I'm fine with that. You good yet? Yeah. All right. Did we hear from Martin? Did we hear from you on this, Mr. French?
Not yet, but you're about to.
Let's make the record clear.
The Planning Department reviewed this application, noted that this property is located in the Fells Point Historic District, and therefore, for the record, wishes to note that approval of the application should be subject to the condition that any and all exterior changes, including additions, demolitions, alterations, and signage, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. And secondly, that the department recommends use of the property complies with terms and conditions of the Baltimore City Code, Article 23, the Sanitation Code. Thank you.
Thank you, Mr. French. Mr. Barry, is your client agreeing with the
Yeah,
conditions?
we have already started discussions with CHAP and well aware of their requirements. Thank you.
And the sanitation requirement as well?
Yeah, sanitation, of course.
Very well. Anything else you'd like to add, sir?
No.
All right, the board, having heard your appeal, I believe we have sufficient information to approve your appeal.
Great. Thank you.
All right, we had a matter that I skipped over earlier in the consent docket. I'll call it again. I don't know if the individual's here. 2022-242, 5111 Plainfield Avenue. Atia Wells. No? Okay.
Should we postpone that?
It's up to you. You can, I think usually the board postpones and lets the applicant reach out to reschedule.
Find out if something occurred.
Yeah.
Yeah, that's fine. We'll postpone that administratively and hope to hear from the applicant again. All right. Thank you. That concludes our consent docket. We'll turn our attention to the contested docket at this point. And we'll start with case number 2022-151, 925 Ramsey Street. Adrian Beagle is the appellant.
Good afternoon.
Good afternoon. You, Mr. Beagle?
Yes.
Good afternoon. Purpose of this appeal, let's see, permit number COM 202-57177 and COM 2021-69492 issued in error. A variance request is never posted. Did I summarize that correctly?
Yes,
Okay.
that's true.
Let's hear from staff and planning, please. So this is a negative appeal, as you mentioned. There is a kind of a timeline in your notes here of what happened over the past year or so. So in March 9th of 2021, this appeal was approved by consent for a variance, or maybe more than one variance. April 27th, the construction permit was issued. And then in August, Mr. Beagle reached out to Katie Byrne, and there are some emails back and forth about what's going on with the neighbor's construction project. There's also some information in your notes about the appeals process and its requirements. From my perspective, looking through the case, and as someone who advises the board, there's kind of two main issues here before we get to substance of the variance, which might require a future hearing. The first is whether or not the negative appeal was timely filed under the board's rules and under the zoning code. And if it was timely filed, then does the board believe by preponderance of the evidence that the owner did not properly post the hearing date before the March 2021 hearing?
What was that last part?
So the second question is, if the negative appeal was timely filed with us, the second question would be, does the board believe that the owner of the property, who was supposed to post the property, do they believe that he did post or did not post before the March 2021 hearing? If it was not properly posted, then the board will need to hear information about the merits of the variance, and that might require a future hearing. I hope that makes sense to everybody on the board here.
Okay. So who do we have here? We have, who else is here for that matter?
Just me.
Okay, so I'm actually going to need you all to at least come up because you're all going to be sworn in if you're going to testify.
Mr. Beagle as well.
Yes.
I'm Mr. Beagle.
Yeah, yeah.
Were you sworn with everyone earlier? Oh, that was consent document, never mind, you're right. You swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
I do.
All right. Okay. So having heard that, let's hear from Mr. French regarding planning.
The planning department actually has no comment on this application, as this matter is strictly, from the point of view of planning, a procedural matter at this moment. Thank you.
Very well. Thank you, Mr. French. All right, so Mr. Beagle, go ahead, sir.
Okay, would you like me to speak on the fact that it wasn't posted or the effects that it's caused me?
Well, let's see. We've got to find two things. We've got to find that this appeal is timely filed. So,
Right, so I guess the first thing that we need to find is whether the appeal was timely filed. So the board has, in the memo here, section 19-301, that's from the zoning code. Interestingly, the code and the board's rules say two different things about when it's timely filed. So that, I don't know what to do about that. But so the first thing is kind of at the bottom of the page here, 19-301, administrative appeals. The notice of appeal must be filed as follows. In the case of any other decision, within 10 days of the date of which notice of the decision was given. And then the board's rule says negative appeals may be noted by any person aggrieved by filing a letter at the office of the board within 10 working days of the issuance of the permit by the zoning administrator. So the board's rules say issuance of the permit. The code says notice of the permit. The problem with notice is that the zoning administrator doesn't give notice of the issuance of a permit, generally speaking. People apply for permits, they receive permits, but it's not as though a letter is sent out or anything like that. So the question then becomes, when was there notice that there was the issuance of a permit? In order to find out whether this is timely filed. So part of the documents that are in your file are some emails back and forth. Obviously, Mr. Beagle can testify about when he first found out that there was a variance that was issued. There's an email from Mr. Beagle to Katie Byrne that says that he's been trying to reach people for several weeks. and that was on August 8th. The appeal was filed August 25th. Let's call it the first appeal, because there was basically the zoning administrator's office didn't accept the appeal right away. But let's say it was first filed August 25th, according to our records. Again, Mr. Beagle can correct me if I'm incorrect. So the email to Katie was August 8th. The appeal was filed August 25th.
I just want to clarify one thing. So 19-301 states, must be timely filed when there's a notice of what again? Just to clarify the differences between the statute and
So
our
the
rule.
difference is whether it's 10 days from notice or 10 days from issuance.
Okay.
10 days from notice of issuance or 10 days from issuance?
Exactly. Well, sorry, was that a question or a comment?
I'm confirming what the
yeah.
notice is,
The notice would be of the issuance of the permit. Mhm.
except that
They don't give
give
notice.
So I guess the notice is when you get, the notice is issuance, or no, it's
Well, I mean, I think this is a tricky situation. It could be from the date that constructive notice is, I notice that somebody is building an addition, and they either have a permit, in which case I have notice that there's a permit, or they don't have a permit, and I can call that in, and they're working without a permit.
Yeah, it would seem that at the very latest, once someone has started work, certainly put on inquiry notice that the permit has been issued to commence that work. Okay. Mr. Beagle, why don't you go ahead and tell us how you learned about this project and when?
Well, when I first saw it, it was, I thought it was going to be 2 stories, what I consider 2 stories. But the basement was 1 story. And I asked them, because it comes out so far, I said, is that like how high it's going to be? 2 stories? And I don't remember what they said, but it ended up being 3 stories. And I found out when I was watching television and the sun suddenly stopped, it turned green because the color of the backer board was green. Everything turned green, and now they have siding on it. But that's when I found out, and I complained in a timely manner within days.
To whom did you complain?
I went to the zoning, this building here, the admin office on the first floor.
Okay.
And I had trouble submitting, I don't know why he didn't submit it. I went to check up on it after 2 or 3 months to check up on it, and it turned out he didn't file it, and he didn't really give me a good reason why.
When you say, who are you talking about?
The guy who approves, he told me he's actually, I forget his name, but he was the guy who approves permits. He said he approves them down in the admin office.
Okay, so you went to the admin office, talked to the individual who issued a permit?
The guy who runs it. Mm-hmm.
Do we know who that is?
If you said his name, I would.
Was it Jeff Veal or Charles Lee?
Jeff Beal or Charles?
Jeff Veal or Charles Lee? Those are probably the two.
Neither of those.
Okay. Then I don't know who you spoke with.
Okay.
Okay. So you said within days of learning about this construction?
Right. And the only way I knew was from witnessing the construction. So, from witnessing the construction, and I can speak about the how I know there was no notice of a variance hearing posted. I can speak on that now if you like.
Okay. Well, did you have an understanding there would be some construction, but you didn't know the scale of the construction?
I thought it would be just normal construction. I was actually looking forward to it, to seeing the improvements. I thought they might put a nice new fence in between us.
And why did you think that?
I'm an optimist. I don't know.
Which house is yours?
923.
What do you consider to be normal construction?
Up to code, which would be 12 feet extended out, rather than what they built was 12 feet plus another 9.5 foot plus another 3 feet of, how do you say it, cantilever, which is when the top level extends even further.
Prior to that construction that you thought would be normal construction,
Right.
were you aware of any notice of that construction? I mean, did you see any signs posted for that? What was going to be built?
I don't believe they posted a permit, to my recollection, but I didn't have, I'm not really a stickler for, I definitely took an interest in what was going on in my street, and I walk my dog every day, and I would have most definitely seen, and I do read when there are things posted on doors on my street, just out of curiosity, okay? Besides that, just to say the other half of how I know this was not posted, besides the fact that I'm out and about a lot and taking interest in my street, is that when we had the previous hearing, we were supposed to have a hearing on May 24th, but somebody on the board lives on Ramsey Street. Okay, so what happened was, I believe her name was Kathleen or Katie, it might have been Katie. Okay, she took us out in the hall and told us that there was going to be a delay for this. And one of the gentlemen complained that it's been so long and they're trying to hurry up and flip this house, while they can, make a profit. And I'm sure that's a concern. Not my concern, but I'm sure that's a concern. And then the other gentleman told her that he used a company to post, that they use a company that will go out and post the notice of variance hearing. And he said right in front of me that he did not go and check up on that. So that's additional proof that it was not posted.
That the individual said he didn't check to confirm whether it
He
was
said he
posted?
uses a company to perform that task. And he said right in front of her and me that he did not follow up on this.
That doesn't necessarily mean it wasn't done, it's that the individual didn't follow up.
Right, he didn't check to see if it was posted. So he doesn't, they don't even know if it was posted, which I do know that it wasn't posted.
Okay. Ms. Witt, what's the record that we have with regard to posting?
So we have, what we normally collect is an affidavit from the property owner or whoever submitted the application, saying that they posted the property properly. I think this one was postponed, and so I think there are 2 affidavits in the file. I can pull them up if you want to look at them, saying that it was posted for both hearings. What we do currently, which is not what we did back when this was approved, now we request photographs of what the sign looked like and where it was posted on the property so that we know for sure it was up. We did not do that at the time of this hearing, and so there is no photograph in the file, but there are 2 affidavits.
Were you here for the March 9th hearing?
Well, even before the hearing started, that's when Miss either Kathleen or Katie, that's when she took us out into the hall. She said, whoever is involved with 925 Ramsey Street, please stand up and go into the hall, and that's what we did. So she let us know we couldn't have it that day.
I think you guys are talking about 2 different hearings.
Yeah,
He's talking about the hearing when
it would have been on Zoom if it's March 9th, 2021.
I wasn't involved with any other hearings because there was no notice of it. I wasn't aware of it.
So you weren't at the March 9th?
Are you talking about the original?
I'm talking about when it was approved by consent.
When it was approved, no, I wasn't aware that there was that meeting that day.
You're saying because it wasn't posted?
Exactly. Mm-hmm.
For a year and a half ago, for March 9th, 2021? I mean, I was on maternity leave. I wouldn't have been here, so.
I guess I'm trying to also understand, in addition to, I know you weren't here March 9th for the consent docket, but when you said you first saw them, around what date did you first know that they were building something?
I don't know the exact date. It was quite a while ago. It was years, more than a year.
It's more than a year.
Yes.
Okay. Did you know that they were building something before? How long before you went down to the office did you know that they were building something?
How long before that? I would say probably about a month or two.
And when did you go to the office? Do you have a date?
I don't have a date, but it was soon after I realized the structure was going to be a problem. At first, it was just an aesthetic problem for me, but it's turned out a lot more than that.
Do you recall if it was spring, early summer when you first knew that they were building something? Do you recall like a time period?
It definitely wasn't winter. That's all I can tell you for sure.
Okay.
Did you go to the zoning administrator's office after you spoke with Katie? Or whoever you spoke with on the phone?
The first thing that I did was I went to the zoning office and filed where it says administration. That's right. That's what I did at first. I spoke with Katie just trying to, I called to find out what was going on. Why, just to check up and make sure that my papers were submitted.
Okay, continue and tell us what you.
The effects?
Let me ask a question first.
Sure.
So you complained when the addition was completed?
No, I complained as soon as I realized, first of all, I knew that it came back really far. Okay, that was plain to see. Okay, and then after that, it became taller than I expected. Once it became taller than I expected, that's when I came to this building.
But you don't know how long into the construction it became taller than you expected. You know what I mean? If it took them 30 days to get from foundation that you thought was normal
Right.
to
That's why
extraordinary.
that's why I said probably a month or two, because that's about the time frame there.
Okay.
But you don't have any documentation of that?
I don't have the exact dates of when they constructed their structure, no.
Okay, go ahead.
Okay, so the way that the effects of this addition, okay, natural resources are limited, the sun and the view. We have, I have my neighbor.
Sorry, what about natural
This,
resources?
the natural resources of the sun and the view. Okay, I used to have a view, now I have a huge wall. I have a neighbor,
What was your view of?
well, I have a neighbor named Rodney, and he did the Schaefer statue. So he has a sculpture garden, which I used to be able to see, which now there's no way I can see it. The view and the aesthetics and feeling claustrophobic, those, and depressed from lack of sun, those are my first concerns. Okay, that was an obvious thing, the aesthetics. Okay, but so now, as far as enjoying my space, I only have the sun from right around 11 o'clock to 3 o'clock, and then after that, it's a lot of shade and it's a lot of mosquitoes, so I don't get to enjoy my backyard anymore. I'm into yoga and getting sun. You know, there's a man named Chris Martinson who I listen to on YouTube, and he was giving advice on COVID, how to deal with that, and I followed all his advice. I got my vitamin D, I got my ivermectin, all kinds of things to combat that, and I would go out in the sun. I got in the habit, starting in 2020, of going out in the sun. Now, when I go out in the sun, it has to be the strongest noon sun. I can't just have like 5 o'clock sun anymore.
What was the issue with mosquitoes?
Well, when the sun goes away, the mosquitoes come out, so I can't enjoy my backyard unless I'm in the direct sun, or it's either direct sun or mosquitoes. Okay, so that's not good. So Chris Martinson, I listened to, and now he's saying he's a scientist, and he works with economists also, and he's saying now, in order to be resilient, what people should be doing to combat inflation and to remain healthy, which is a strong interest of mine, is that they should be growing a garden. something that I don't have that option anymore unless it's scaled back to code. So this is costing me, I just bought 3 tomatoes yesterday at Whole Foods, and they cost $3.50. And that's for 1 pound of tomatoes. That was 3 tomatoes. Now, if I had the option to grow tomatoes, I would have instead bought a plant, and that would produce 10 to 14 pounds of tomatoes, costing me about 90% less. So these guys are costing me money. I have grown tomatoes before, and I would love to grow them again. Let's see, any other points I have?
August 8th.
Oh, also, when they constructed the house, they were very careless. They took I had a neighbor on the other side at 927, okay, Ramsey, and he used to have a big garden, and he's gone now. Okay, he moved because he can't make his garden anymore. And also, he had rats come into his house because when they removed the joist from the wall for the renovation, they didn't patch up the holes. So I'm left with a large hole. I was able to patch those up. Okay, everything that they did, I was able to patch it up. I used that backer board that you use before you tile. I put that on there and caulked around it, so I didn't get any rats in my house, fortunately. But I can't fix this other issue with a lack of sun. And the view I could deal with, you know. I can deal with all of it, I suppose, but it's taking away my ability to be resilient and enjoy my backyard space.
Okay.
That's
So
basically.
let me ask you, given all that, what would be a resolution for you?
For it to be built to code like every other house on my street would be excellent.
Is it constructed already?
Not 100%, but mostly.
So you'd like to tear down part of the construction?
Yes, just to go out 12 feet like everyone else would be, I would really appreciate that. It would change my life.
If you're facing your house, the house directly to the left of you is 3 stories. It's already tall, so and does it go back as far as your house or?
No, my house doesn't have any additions on it.
Right.
So it's set back. And so that.
I'm looking at it on Google Maps, but it's from
Okay,
2020.
if
so.
I'm sitting on my deck
Yep.
and I'm to the left of me would be that taller house. And also there's a tall building back there, okay? And so that blocks a lot of the sun. But it didn't bother me because in the afternoon, there were no additions. There were 2 more houses past this house, and neither one of them come out very far, okay? Maybe the one on the end does actually, but I could still get all my sun, and I could still get the view of the park, and it was fine, you know. But this is, I think they've used about 90% of the space available.
Essentially, if this house is built to the way that you say it's being built right now, your backyard being closed kind of on 3 sides all the way.
Yes, my view of the sky is a triangle now.
I understand.
I have no view even worth looking at.
So let me just confirm something. Your testimony is that you raised the issue when you understood there was a problem.
Yes, I didn't want them to. In fact, they wanted to put siding on my house, okay? And they had that structure, the thing that you stand on. What is that called? Scaffolding. Yeah, scaffolding up in my yard, and I asked them to leave, and they said, "Well, why don't you just let us set the scaffolding in the yard? We'll give you." They offered me money for that. I forget how much, maybe $500. I said, "No, thank you. I don't want this project to go on because it's not, you know, I don't think you should continue because I have a problem with it, you know."
Okay. Is there anything else?
I'm still unclear as to notice of the hearing, and then the time in which the appeal was granted. I mean, I have no idea what we're looking at there.
So there is testimony that we haven't heard yet from the property owner who is here, who can perhaps clear some things up. So So from our perspective, the applicant met his burden for the original hearing, which we granted by consent, because he submitted the affidavits that were required at the time.
So it was posted.
Well, he submitted the affidavit that said it was posted, and that's all that we required.
He complied with the rules that we had in place.
That's why we postpone cases all the time if people do not submit their affidavit that they're required to submit. So we received the affidavits that said that it was posted, and so that's why we proceeded with the hearing. He complied with our requirements.
But I think it's what Mr. Beagle's saying, that to his knowledge, the person who completed the affidavit is not the one that did the posting because they hire another company to do the posting for them.
Microphone.
Oh, my bad. I was so on Bill. So if I understand what Mr. Beagle is saying is that to your knowledge, the person that completed the affidavit is not the same person that would have been in charge of posting the sign, because you think they hire another company to post the signs for them.
From what I heard them say, yes.
Okay, and you walk every day and you looked at this house and you never saw any, the signs are giant. You never saw any sign on the front, side, back
Yeah.
of this, okay.
Right, so it's up to the board then to decide
And
that
also,
matter.
I'm sorry, I'm so sorry.
That's okay.
Also, I had an affidavit from Rodney, the guy who made the Schaefer statue. So he said he didn't see it either, and I had one other neighbor to write an affidavit saying they didn't see it.
Okay, so I understand, okay.
So
Where are those affidavits?
They should be submitted,
They're a part of our file?
hopefully.
So as to Bill's second question, from the board's perspective, it is difficult because of the reasons that I already went through. Whether the board could use its own rule, which says negative appeals have to be filed within 10 days of issuance of the permit, and we know the permit was issued in April, so that would not be sufficient. Or the board could use what's in the code, which says within 10 days of the date on which notice of the decision was given, in which case we have to figure out, and this is what you've already been doing, on what day was there notice that there was a permit issued in this matter, and then count the 10 days from notice of the permit. And there is also, I believe, testimony from the owner as well about when notice of the permit was given. So again, the first negative appeal was filed August 25th. The permit was issued April 27th. And there's an email in the file from Mr. Beagle to Katie that is reposting what he said that he posted on Nextdoor, which says, the house next to me has a huge addition. Normally additions come out 13 feet, but my neighbor added another 9 feet, leaving about 8 feet of backyard space. This blocks the view of the park for me and about 10 of my neighbors. They obtained a variance, but didn't post notice of the variance hearing. I've tried for several weeks to contact the zoning department, but haven't been able to. I'm wondering what to do next. And presumably as a comment underneath that Nextdoor posting, someone said, contact Katie Byrne. And then he did on August 25th, according to the emails that we have.
So essentially, our timeline, in addition to me clarifying your testimony, is that March 9th, we have the hearing. April, there's a permit that's issued. You're stating at some point you saw them building, you thought it was fine because it was going to improve, and then at some point it got so high that you complained around like August at some point. And at this point, you've seen them building over a couple of months?
Oh, yes, the building
Okay.
had been definitely further worked on since I complained.
No, I mean, before you complained, it had been worked on for a couple of months?
It was just the basic structure, the green board
Okay.
was up. The 2x4s were up.
So when you saw that construction had begun on this rear addition, did did you think, hey, I haven't seen a permit about this, I haven't seen a notice, a sign put up about this project? Did that raise any alarms to you then when you saw the project begin?
I honestly don't remember if they posted the actual permit
That's not what he's
as
asking.
they built the
Well,
house.
your complaint is that, your negative appeal is that they didn't post. However, you said that you waited until, not when you saw construction begin, but until a little later when you saw that it was getting a bit higher than you thought it
Right.
was. But you want to notice that at least a permit
Well,
might have been issued.
I asked the guys, I said, how high up is that going to go? And they said 2 floors. And so I'm thinking it's like the basement is 1, and then the main level is 2. But actually, the basement doesn't count for some reason. I don't know. And then it went up a 3rd level, and that's when I realized that I was blocked in.
Okay. Here's a question for you, Ms. Witt. The permit is for two-story construction?
I can pull up the permit. I
Well,
don't know if I have
Mr.
it.
Beagle, are you
Yes.
contending that what was built was beyond the scope of the permit?
Well, I know for sure that it, not the scope of the variant, of the approved variant, but of code, yes.
So I don't think that there's any allegation that.
There's no
the
issue that
the
what they
work-
built was improper.
Exactly.
Okay.
The work is according
So-
to what we approved.
So you acknowledge that building commenced at date certain, and when it had commenced, you were okay with whatever it was they were building because it didn't occur to you at that time that it was larger than you thought it would be, right?
Well, when I first saw how far out it went, I realized that it was almost twice as far as anyone else's. I realized that, but it didn't really bother me because I asked these guys how far up, so I didn't have my view blocked at that point.
Okay, stop for a second. There's no allegation or contention here that what was built was outside the scope of the permit or beyond the scope of the permit. You acknowledge that when the construction began, there was likely a permit that was issued, right?
A permit, yes.
But you didn't inquire about a permit when you knew that construction had commenced, right? You waited until it became a problem in your mind.
Exactly.
And based on what you understood.
Exactly. That's
That,
true.
however, was sometime down the road after construction had commenced.
Not that far, a month or 2.
More than 10 days, right?
More than 10 days.
Okay.
Well, I didn't know the details of the house,
I'm
really.
not talking about the details.
Okay.
The detail I'm asking you about is the detail of construction commencing.
I didn't know how high up it was going to go.
I understand what you didn't know.
Okay.
But what you did know is that construction had commenced at a date certain, right?
When I saw the construction had began, I should have let that bother me before it bothered me.
I'm not asking, I'm not doing the hypotheticals here. I'm asking you factually what you saw and then what you did based on what you saw. You saw construction commence, right?
Right.
And then you said you saw it even go out further.
Okay.
But then that didn't concern you because you asked someone and someone said it was only going to go up so high.
Maybe I can answer like this. If something is not built to code, I don't go and complain about it unless it affects me.
Okay. Is your contention that this was not built to code or based on the variances or approvals that they got?
It was built in accordance to the variances,
Okay.
which at first I didn't have a problem with.
Okay. I think that's all we need to know.
Okay. Sabrina's going to recuse herself, just FYI.
I'm the one that lives on the street.
Oh, okay.
Yeah.
Second of all, okay, that's it, sorry.
I mean, you can tell them all. It's fine. You can have to go home. Go to the bathroom.
Sorry, there is also, the property owner is also here, who might be able to provide a little bit of clarity on a few of the things that
Right.
we have questions about.
What I would like to do, I think we've established what we need to know, but I can think that we can make the record clear. Maybe we have I'd like to hear about, again, well, not again, I think I've heard from you, your evidence on notice, and when you had it, and what you did with it. I'd like to hear from the opposition or the respondent with regard to the issuance of the permit, the notice given with regard to the first hearing. So I'm going to ask you to step aside, Mr. Beagle, if that's okay, so that I can hear from the owner with regard to those issues. Good afternoon, Mr. Prettle and gentlemen. Thank
Chairman.
you for coming.
Here, Nate Prettle, on behalf of Steve Wheeler, who's the contractor and the owner here. You can introduce yourself.
Norman Day.
Okay.
Good afternoon, Mr. Day.
And I want to be very quick to address these points. And first, I do need to state that the contractor and the owner have gone by the book and followed all the proper procedures from the very beginning, from applying to the zoning board, from posting the property, from obtaining a building permit afterwards, and even stopped work once this has happened. And this is significant hardship to, again, an applicant and property owner who have followed the book to the T, the entire process. And in regards to, the issuance of the negative appeal or the filing of the negative appeal, whether you want to go by what the zoning board rules say, which is 10 days from the issue of a permit, we're about 4 to 5 months past that period. And even if you go 10 days on notice, I know there was a lot of, maybe not definitive testimony there, but I have forwarded Ms. Witt an email sent with a chain with both of these gentlemen on it that has a copy of the plans and the building permit that's dated August 2nd, 2021. And it's my understanding that they were in conversations with Mr. Beagle well before that. So, at the absolute latest, he had a copy of the building permit and plans 2+ weeks, or what was I forget the date, is it August 25th? 25th, about 3 weeks prior to him actually filing for that negative appeal. And that's at the absolute latest. Yeah, and the plans had been shown before that. In regards to the posting, Mr. Wheeler here posted it himself, and the sign was created by, I believe, Gina Campbell at NW2 Engineers, a firm that I think many of the board members are familiar with. And it's typical for them to create the sign and either post it themselves or give it to the property owner. And the affidavit was signed and submitted, as required. And I think there have not been any issues regarding affidavits being filed and signs not posted with NW2 in the past, and I'll let that stand for. Other than that, we don't have a lot. It seems to me it's pretty clear that one, the initial variance approval should stand, per the posting, and that the negative appeal was not filed in a timely manner.
Okay. As you gentlemen were intimating that the communications you had with Mr. Beagler, could you tell me about that?
They were almost immediate. We obtained our permit in April. We started construction almost right away. We had a footer inspection. We had our footers put in exactly to the specifications we applied for with the variance. He obviously seen everything going on. He lives right next door. We then
You can see how far it comes out by the footers and the
we
block
built we built the structure. I think his main issue was later when it started going up. The back area, as you can see on the permits, what we applied for, there is a crawl space area that he keeps considering as a story, but it's not. We did a 2-story addition, which we applied for. It's just to meet the level of the grade.
The elevation of the house or the back is way lower than the front.
So there's no basement area back there. It's a crawl space. It's not livable space back there, which we indicated on the permit, and everything's been inspected, approved.
We've been out with Keith and Dontrell, I think, measuring the addition more than once.
Right.
Length, height. And we've been stop work. And
He was aware of he was aware of everything. I'm sorry. He was aware of the addition in May. And everything was fine until he thought that was a 3-story instead of 2-story, which it's just how the construction is.
And when you say he was aware, Mr. Beagler was aware of the addition in May, how do you know that?
Because the footer was built and we had an inspection done.
Okay.
So
Mr. Chairman, if I could clarify, Mr. Day mentioned that he had Don Trell out there. I think many of you know Don Trell Jones is the head building inspector, and part of that was not only as part of normal inspections, but when this whole negative appeal came out, the HCD has been out there and verified. So there were some questions about whether or not there was contention that this is not built to the plans, to the approval. I think that has been sort of double checked by HCD as part of this as well.
Okay. All right. I don't have any more questions. Any questions? Go ahead.
Okay, I understand you started in April. By May, you had the footer. The only question I have is for the August 2nd building permit. What is that in reference to?
That August 2nd date was later down the road when he asked to see a copy of the plans, which I had then emailed to Mr. Beagle.
Oh, so
August 2nd, and I believe she has these now.
If I may, the August 2nd was the date that, at the latest, that April 20, whatever permit was sent and has document for an email, an electronic record of that. So
It's
no
on the
later.
window,
It was the April permit, that, it was on the window, but it was emailed, and there's now, will be in your record, a copy of it to Mr. Beagle on August 2nd. And the point I was making that the August 25th, even if none of the, we have a lot of testimony of him being aware of it prior to that. Even if none of that had occurred, he still had a copy by August 2nd via email, and which is 3 weeks prior to.
And so, sir, you said that you personally posted
I
the notice?
posted the sign.
Okay.
I didn't make the sign. What
But
he's
you
saying
posted
is
it.
NW2 made the sign, I posted. I can't, swear to you that it was there all the way up to the hearing. I don't,
That was
I don't go there every day and check.
But an
It was
affidavit was
abandoned house.
submitted
But I signed
Yeah,
that affidavit
fine,
twice
that
and submitted it.
and accepted by the BMZA, and the hearing went forward without issue with regard to posting.
Yes, sir.
Okay. All right. Anything else from anyone? Yeah, we do. Okay, thank you. Mr. Beagle? Is there anything else you'd like to add with regard to notice in light of the testimony we just heard?
I don't think so,
Okay.
unless you had any questions.
You have questions?
So do you agree or I guess admit that you got the plans on August 2nd?
I did ask them to see the plans, and they showed me the plans.
Okay. All right, thanks.
Thank you.
I also just want to make clear for the record that that August 2nd email is not in your packet because it was just forwarded to me during this hearing, but I can make it part of the record, the email on August 2nd. It's weird because today is also August 2nd, so it's a year ago today.
And today, in the record, the date of the negative appeal, the filing of negative appeal is August 25th, 2021.
Yes, that's what we have.
Okay. All right. I have no further questions. All right, Mr. Big, I think we're done.
I'll hang out and see what happens, right?
Thank you. Can we proceed to deliberate on this? Okay. Based on the testimony that's been presented, there was a permit, in fact, issued in April of 2021 for the construction that's at issue here. Testimony has been put forth that construction commenced almost immediately, footers being put in place. That alone, to me, is sufficient information to put one on inquiry notice that a permit has been issued. The testimony of the movement for the negative appeal has testified that he was aware, in fact, that construction had commenced, and given various times as to when he took action after becoming aware that construction had commenced, of a month and a half, sometime down the road. Saw even, became aware of a concern when it looked like the construction was moving out further than he expected, but was somehow disabused of any notion that was a problem because he believed it wasn't going to go up but so high. But all this is notice that construction had commenced, and an inquiry notice, certainly constructive notice that a permit had been issued. And then we know, in fact, that the witnesses testified that, or all parties have testified that Mr. Beagle received a copy of the plans at the latest on about August 2nd, which is 23 days prior to the effective date of the filing of the negative appeal. Under any scenario, that certainly more than 10 days after the issuance of the permit, which was issued in April, and more than 10 days after Mr. Beagle had received notice, constructive notice of the issuance of the permit, by virtue of his observation of the construction that was going on next door. So based on the record and based on the application of Article 32, Section 19301, I believe that the negative appeal has been filed untimely. It's well past the 10-day period for either, again, 10 days past the issuance of the permit or notice, in this case, constructive notice of the issuance of the permit to Mr. Beagle. And so I believe the negative appeal should be denied.
Yeah, I agree with you, Mr. Chair. And I'd also like to add that the building is built within the variances that we approved. I believe it should be denied also.
Also means it should be denied.
I have to agree as well. I mean, I understand your position, but given the statute and given our own rules, even if we were to use the August 2nd date, like the chairman said, it would still be more than 10 days. So I have to agree as well.
Okay. We good? All right. Thank you, folks, for your presentation. Case number 2022-232.
Start building again?
So I'll have to write a resolution. But you can check in to see the status of that. It'll probably take a couple weeks for me to write the resolution.
Does it work the same with the negative appeal as it does with the, because they've already been working, so it's not like they need approval. This is just a procedural question.
I think I need to write a resolution about why it was denied.
Okay.
So we'll be in touch.
Thank you, guys. Thank you.
Right, thank you. Okay, case number 2022-232, 834 North Bendlow. Tanya Bell. Hey, come on up to the podium, ma'am. And is there anyone else here for 834 North Bendlow? Come on up, sir. No, I'm gonna have him sworn.
Yes.
All right, ma'am, this is a request to use the basement as a hair salon and spa.
Actually, it previously was a hair salon. It's a nail salon and spa with facials and waxing
Okay,
services.
so what do you want to use it as specifically?
Continue
as a nail salon?
Yes, nail salon and spa. The spa side is just facials and waxing
Okay.
services.
Wait a minute. It says, what I have in front of me says hair salon and spa.
I know, and so when I contacted whoever wrote it in, they just used hair salon, and
Okay.
they said that I didn't need to change it because it was
Same
falls
thing.
under the same purview.
Okay. Hail/nail salon. Nail salon.
Oh.
Okay, here from staff and planning.
Okay, so this is a request to use for neighborhood commercial, and all of these kind of similar categories fall under personal services establishment. So hair salon, nail salon, whatever kind of salon is personal services establishment under the zoning code. So it doesn't matter which kind. There is a long history of commercial uses at this property over the years. It's been used in the 1930s for stores. In the 1960s, it was a beauty shop. 1974, another store. 1977, grocery store. And then 2003, barber shop. So it qualifies for neighborhood commercial. And so it's a conditional use for this use.
Planning Department reviewed this application, noted that this property has a record of use as a personal services establishment, as you've heard, or as a retail goods establishment. Both of those are neighborhood commercial establishment categories. Therefore, the property itself is qualified for use as a neighborhood commercial establishment, including a personal services establishment. The department, therefore, is recommending approval of this application. Thank you.
Thank you, Mr. French. Okay, Ms. Bell, you want to just tell us about your project briefly?
So it's actually not too far from Carver Vocational Technical School, who also has a cosmetology program. I also have a couple young nieces that are interested in the beauty industry. So this was a way for me, the owners of the building itself, they had the rental space as previously commercial, and we got together. I've known it for 35 years. We went to high school together, and decided to have a space in the neighborhood, in the community, that people can go and get these type of services, self-care, and that was the thought process behind wanting to have it in this area, to hopefully pull in maybe some of the young students that are in the cosmetology program, that they can have a safe space, that they can come and be able to learn in an actual business setting. So this is something that I've been working on for over a year. We had a location in Houston, maybe about 5 months into the pandemic when things started to open up, and I just couldn't get really any traction. My son was living at the time. And then we also opened up a location in Brooklyn. And again, it was just really difficult. So this kind of opened up for us, and it just made sense, especially, to try to bring something within the community. So.
Okay. Well, thank you. Any questions for Ms. Bell this time? All right. Okay, ma'am. You can step aside and we'll hear from the opposition. State your name, sir.
Good evening. My name is John Carrington. I'm president of Bridgeview Green Lawn Neighborhood Association, vice president of ARCO. Okay, before you, the last time I was in front of the board is the time that I brought 200 petitions and Bullock and a couple other. This time, my concern was that I didn't see it posted at the present time, and it's directly across the street from my church, Catacorn. Okay, we had some concerns because it's 834 Bentlow Street, but they actually will be coming out on Lafayette Street, which is on the corner, which is there's a shortage of parking. There's a lot of other conditions in terms of some problems, which is directly across the street that we at one time trying to close it. I don't have any problems. It's been 5 years since that particular building has been open, so I'm looking at does it need renovations, which I think stayed up because I just recently had a house across the street that they were doing some of the same particular work, and it caught on fire, the lady house twice, and she lost her insurance the second time. And I have some concerns. I'm willing to talk with them, but I have a group of seniors, and everything is right now that's jumped sky high. I mean, went over $100,000 in less than a year in terms of the property values and whatnot. And my concern is that last time I came before the board and stuff like I told you, I brought 200 some petitions, and I also turned around and had pull out the councilman and things of that nature. I just wanted to sit down with her and talk with her because right now there is a shortage of parking. I don't know exactly where they're going to park at. I don't have too much against this stuff like that. How clean will you have it in terms of that? Because that is a Lafayette corridor and things of that nature. So, this is one of the reasons why I opposed and stuff like it. Had I known in advance and stuff like that, I probably would have brought you the same thing I brought you on the Harlem Street project, 250 signatures and councilmen, and also the assistant of the mayor. Because I talked with both of them just briefly, but I didn't tell them to come down because I thought that I could communicate with this young lady's first time I saw her, even though I'm there on a daily basis, because it faces, like I said, my church. I'm normally there 4 days a week, but I work at another job 5 days a week in the evening. So this is where some of my concerns are.
So you're concerned about parking?
Not only parking, my concerns about some of the safety features in some of this property, since it had jumped, it came sky high. I know a couple of, like I said, houses that's less than a half a block up caught on fire twice, and the lady next door and stuff like that, but they were doing some renovations and stuff like that. And she lost her second insurance because the insurance didn't want to pay it the second time that the house next door caught on fire,
Okay.
you know.
Okay. You could just ask her. Or you know, there's been an issue, for example, in the past where people hadn't, you know, properly secured their property or anything like that, and there was an unfortunate fire, and there was a loss. I just want to keep you, you know, make you aware. Okay, assuming she's done all she needs to do to secure the property and to, as best she can, preclude some unfortunate event like that, which could happen to anyone. What then is your opposition? Assuming safety issues are resolved.
With the safety issues, well, the safety issues is some,
I said assuming the safety issues are resolved, the safety issue that you've identified.
hasn't been, or safety issues haven't been resolved in maybe the last 20 years and still not today, so.
Okay,
You
so,
know, because it's not only her, she has a store run across the street. No, you don't. I know you don't. But what faces you is the store. That's not.
okay.
You understand?
Hold on, ma'am.
Because
We'll give you an
remember, you're
opportunity.
coming from,
Sir, talk to us.
you're coming from Bentlow Street, which her spa and stuff is gonna come off of Lafayette, okay? Which that's the door they're gonna come out of Lafayette, okay?
You mean the pedestrian traffic, people come out the door
Yeah, yeah.
on the side?
The house is Bentlow on the corner, okay? But the door downstairs in the basement comes out of Lafayette, okay? Which is a major thoroughfare, and it's, like I say, parking is sometimes can be a major issue.
Is there a parking variance associated with this?
No, it doesn't need a parking variance because of the small square footage of the site.
Okay, parking's not an issue. Assuming parking's not an issue before us,
Well,
what other issues, if any, go to your opposition?
I'm not gonna go to this particular thing because it's a lot of things that's curtailed for the entire city that needs to do, so.
This is the time to bring
You're at the hearing.
You know, well, it's, that particular corner area has a major drug problem in terms of people going back and forwards in that particular store and things of that nature. That's one of the issues. The other issue is.
Let's take that issue. Do you believe that the project that she's proposing would contribute to the drug issue in the store?
No.
Okay,
no,
so then
no,
that's not an issue before
No,
us.
I'm not gonna put her in that time that may be the issue.
Okay.
That's the issue right now.
Right, I understand that, but today, what you're here in front of us for today is issues about her project specifically, not about the general problems that, you know, face a city, or it's how her project affects your neighborhood, kind of. So that's what you need to talk to us about.
Well, that's one of the particular issues that she said that parking is not a problem.
Well, parking is.
It's already one now.
So here's the thing with parking. The way we understand it is that the space she has is so small that there's no way she can fit a ton of people in there that would cause an additional parking issue.
Okay.
So that's determined. Is that a fair summary of the law?
Yeah.
Yeah.
I would just add that for neighborhood commercial establishments, the idea is that they're providing an amenity to the neighborhood. So people will come from nearby who might not need to drive, who could walk across the street or whatever within a few blocks.
They might
And
come
so-
from your church and go across the street and get there.
So the parking requirements are relaxed for these kinds of uses because the idea is that you're providing something to the neighborhood itself, not for people to drive from long distances to come to.
Okay. Is there anything else, sir?
Not at this time, particularly at this time, stuff like it, but there are some major concerns, but
Okay.
I'm not gonna put it all
Thank you.
down.
Can I ask a question?
I think the councilman knows about it.
Sure. In the requested use relief, two paragraphs or a paragraph and a sentence, it says that the conditional use of the basement for a barber shop, certificate of use and occupancy was voided for the barber shop on 8/6/2012. The next sentence, you say, accordingly, the applicant seeks to reinstate a prior NCU that was discontinued by operation of law, which is not permissible under the zoning code.
Yeah, so the application was, this was from John's staff memo. The application was forwarded to us as a continuation of a non-conforming use. So it is true that the former non-conforming use was abandoned because it was vacant. But it's also true that this property is eligible to apply for neighborhood commercial because of the history, the commercial history there. So,
Why are we looking at this language?
yeah, I think that's just a mistake. It's an oversight on John's part.
Okay. All right, thank you, sir. Ms. Bell, we'll hear from you. You have the final word.
So I'm not the owner of the building. The owner has two properties, rentals that she has upstairs. So like I said, the basement hadn't been used. And to your point, I've lived all over Baltimore City, county, all over. And whenever you want to go get those type of services, you have to travel out to different areas that are not in your community. So to that point, we wanted to have something in the community where people can come. Trust me, we've been there for months now, like, checking out the place, seeing what things we need to be done. There's no major renovation. It was, an empty basement, basically. A lot of stuff had to be cleaned out. So we just had someone come and look at electrical yesterday. As far as the parking, there's a bus stop right on the corner. So hopefully that'll be what's used because there isn't a lot of parking. We're closed on Sundays. That's the hope, to be closed on Sundays, so it wouldn't impact your parishioners coming for services. And also, we have concerns about some of the activity at that store across the street. That hasn't deterred us. We can only do what we can do. So there's security systems. The owner has a security system for her building, and we have a separate one, so it's double. That will go directly to the police department. We will have motion lights outside. Since we've been around, we do see people that may want to hang out. We kind of step out. They ask what we're doing. They leave. So we're hoping that, having something like this in the community will kind of deter people from hanging around in, Lafayette, Bentlow, and all the other streets around. And there's also right across the street on Lafayette, but across Bentlow, another salon that's in business. So again, we've been there. People have asked. We definitely would have welcomed any kind of conversation.
Okay.
That's it.
Thank you, ma'am.
I have a question.
Okay, go ahead.
Not for you, I'm sorry. I'm sorry. What variances are being requested?
I don't believe there are any variances
No,
being
just conditional.
requested.
And what are we considering?
It's a conditional use, neighborhood commercial, personal services establishment.
That's it, just conditional use.
Yeah, I know, but I'm not seeing any information I'm looking at.
Yeah, it was forwarded in a strange way from downstairs.
I'm
from,
just saying, this isn't really helpful to us when the information isn't correct.
I hear you.
All right, let me run this. Who wants to do the listing for conditional uses?
Sure. As far as, this is variance. Mine's folded up in my purse somewhere. So for conditional use, once again, I think we can skip straight to Schultz v. Pritz. In that we are only permitted to deny conditional use when facts and circumstances show that the particular use at the particular location would have adverse effects above and beyond those inherently associated with use as, with such a use, irrespective of its location within the zone. because a conditional use is prima facie, law school, compatible with a given zone. So I would say that we are, based on that standard, we cannot deny the conditional use in this case. But in addition to that, the establishment, location, construction, maintenance, and operation of the use that the appellant proposes is not detrimental to or endangering the public's health, safety, or welfare. It's not precluded by any other law or urban renewal plan. It's not contrary to the public interest. I actually think it's in support of the public interest in that area. And it's not disharmonious with the purpose and intent of the zoning code. So for all of those reasons, I would say that the board should approve, is my vote that the board approves the conditional use of the salon, barbershop, nail salon? Yes.
So that was a motion to approve?
That was a motion to, yes, motion to approve.
Yeah. I mean, yes.
I'm yes as well. I think I was also just add that under the, I can't recall the section, but the neighborhood commercial uses, it also applies to that as well.
It does, and so there are a couple additional requirements that it be pedestrian, oriented towards pedestrians, and that the principal entrance be from the street and not interior, which both of those things seem to be met here.
Need to be mentioned. Oh, so, yeah, actually, interestingly enough, from the opposition's testimony, he keeps saying that it opens right onto Bentlow, or no, Lafayette. It's on Bentlow, opens onto Lafayette, which is a street that people walk on. And what was the first one?
Pedestrian oriented.
Well, yes, if it's on a street that you can walk into. And if you're not providing parking, it's obviously meant for pedestrians.
Okay. Are we done? I think you can tally that vote? Okay. Thank you so much for your presentation. Good luck to you. Calling case number 22. Yeah.
You didn't get bills, I think.
Did Bill not vote?
Oh, I approve.
Okay. It's a little bit dramatic, but okay.
Anticlimactic.
All right. Case number 2022-238, 840 West 33rd Street, AB Associates. Okay, this is a request to consolidate, demolish the existing structure and to construct a two-story structure that will contain a dwelling unit art studio. Is that correct, Mr. Barry?
Yes, that's correct.
All right. And so who do we have all here for the appellant? And opposition? Is there any opposition here?
No opposition, I'm aware of.
The opposition is from planning.
Oh, okay.
Dark horse.
All right, could you swear the witnesses?
Do you swear or affirm on the penalties of perjury that the testimony you're about to give is the truth?
Yes, I do.
All right, I'll hear from staff and planning.
So variance is being requested here. Accessory structure height 15 feet is allowed, 25 feet is proposed, so it's a 10-foot variance. Rear yard setback 25 feet required, 20 feet proposed, 5-foot variance. An interior side yard setback 15 feet is required, 0 feet is proposed, so it's a 15-foot variance. I will let planning speak for themselves on this one. There are 4 letters of support in the file from adjacent neighbors. Oh, sorry, before Martin, real quick. The art studio being requested here is for personal use. It is not a commercial art studio use. It's just, so I just wanted to highlight that because we had a similar case to that earlier. We don't need to go through any factors involved with art studio. It's for home use, so.
Okay, thank you. Planning Department reviewed this application and noted it covers 2 separate properties at the moment. One is called 840 West 33rd Street. The other is an unaddressed property known as Block 3511, Lot 90. And the proposal for the two-story structure, which would include the art studio and a dwelling unit, would be to place that building on block 3511, lot 90. And the problem with that is that under the standards for residential development in Baltimore City, a residence cannot be built unless it fronts upon a public street. That alley is not a public street, at least not at the present time, and therefore it's not possible to build a dwelling unit on that lot as it now exists. The planning department acknowledges the concept that in this particular zoning district, if two separate single-family dwellings, properties were consolidated, that creates a multifamily dwelling unit use of the consolidated property. So the problem then is, which is going to come first? And as we see it, as the planning department sees it, what has to come first is approval of a single-family dwelling unit for block 3511, lot 90, which is not possible, not necessarily under the zoning code standards, but under the standards for residential development in Baltimore City. If the lot was consolidated first with 840 West 33rd Street, then this becomes a question of a single-family dwelling structure with an accessory structure in the rear that is being proposed to be converted to a second dwelling unit, which then constitutes creation of a multifamily dwelling use of the consolidated property, which in the R6 zoning district, where this property is located, is not something that is authorized by the zoning code. The board is not authorized to approve conversions of single-family to multifamily use of property in the R6 zoning district. So that is the essence of the planning department's recommendation for disapproval of this application. Secondarily, at the time that it was not clear what the art studio was going to be, the department noted, for the benefit of the board, that it would not be possible to use the block 3511, lot 90 structure for an art studio, which would be a neighborhood commercial establishment use if it was a commercial art studio, because it could not qualify as a building or as a lot with a building on it, because one of the requirements for neighborhood commercial establishments is direct access to a street, and the alley is not a street at the present time. And so that is essentially a technical reason that the department is recommending disapproval of this application, specifically that the board is not authorized to approve conversion of a single-family dwelling to a multifamily dwelling in the R6 zoning district where this property is located. Thank you.
To our council, so do you agree with the statements he made?
Myself, I'm not sure that I'm qualified to give that kind of advice. I'm taking notes on
He's
behalf of
just sitting in.
DFC.
He's just taking notes today.
My apologies.
Well, I'm technically the staff counsel and the acting executive director at the same time.
Lucky you.
Yeah, it's a lot. We'll see. So I think Mr. French has made a compelling case that is based in the code. It's difficult. I mean, Mr. Berry has arguments that he would like to present, obviously, to the contrary. I think that we obviously need to be careful about conversions, and we hear this every 2 weeks. I don't know if, since I have been with you, that I've had a question of a conversion where it is two separate structures. This is not one structure. It is an existing structure, and then they plan to, I believe, demolish or renovate a garage type space on a separate lot in the back. So that creates a difference from many of the cases that we've heard in the past that are similar.
Okay, Mr. Berry.
Al Berry, the Associates for the property owners. Jason Bartholomew is here with me. He and his wife own the property, and to clarify one point, the existing garage property was consolidated in May of this year by the city of Baltimore. Since we're going to be talking about this, I want to pass around just pictures of the garage so you see what's being replaced. And also refer you to this plan, which should be in your folder, which is a site plan that shows the neighborhood conditions, the existing garage, and the proposed replacement dwelling, which I will argue is absolutely permitted by code. And Mr. French's comments are not relevant and appropriate. And had he called us, he might have worked this out. Let me pass this site plan. So there are two issues that planning raises and come up. The first is whether this is a conversion under the standard 9-701. I will argue that the language in 9701 applies to conversion of single-family buildings, not single-family properties. It's a big distinction. And what this proposal is for the Bartholomew's to replace this garage. Now it's been consolidated with their property, and replace it with a single-family dwelling, an art studio for their use, for their parents, one of the parents of the Bartholomew's. The property, were it to be, now that it's consolidated, the property would be allowed to be everything torn down and replaced with 4 multifamily units. In this case, we're going to have 2 single-family dwellings. There is nothing in the code that prohibits a single-family dwelling on this property now that it is consolidated. And in fact, there's a section of the code, 18601, that would have allowed on a lot of record, independent of the street frontage, they would allow you to build a single-family home. Except that if you own the property next to it, you then have to consolidate it. So we're consolidating it, building 2 single-family homes. Single-family use is permitted in R6. Doesn't say you can only have 1 house on a lot. It also has a yard requirement for each single-family detached house, which is 3,000 square feet. The row house that the Bartholomew's live in is 1,500 square feet, which means that the combined lot area to permit this is 4,500 square feet. We have 5,400 square feet on this property. If you look at the site plan, you'll see it's a rather unique property. It backs up, first of all, to a U.S. Post Office parking lot. It is almost twice the size of the average house or average property on 33rd Street. So we think we meet the uniqueness standards completely. Also in the zoning code, there's something called maximum lot coverage. You have a 60%. In this case, 3,200 square feet would be required as the limit on the 60% lot coverage. We are under that by over 1,100 square feet. So we don't need a lot coverage variance. It's not like we're cramming a building into a small row house block. This particular property goes back 150 feet. If you look at the rest of the properties, I think there's one other, but it's not as large as this. So we think it meets a unique standard. We think the zoning code does not preclude it. The conversion standard only applies to buildings, not properties. It would be otherwise allowed to tear everything down and build 4 units there, which we're not doing. It's for a homeowner and his family. The art studio, this has come up, I guess, before the board. There was no intent to have a retail facility. This is a personal use art studio. It's a permitted accessory use to the single-family dwelling. So with that, we'll answer any questions. We work with the neighbors on this. We think it's an attractive building. It's going to replace a vacant, abandoned garage. It's been consolidated, so you eliminate the street frontage aspect that Mr. French is talking about. And we think I'd like to think the board would approve this, and we have neighbors here testify in favor of it. I think you have the authority, and if there are any questions of myself or owner or the neighbor, be glad to try to answer.
Any questions from the board at this time, Mr. Barry?
I had a quick question. What was your distinction, what was the basis for your distinction between, you said single-family buildings and properties? Was that one of the?
The conversion standard in the zoning code, which was designed to make it more difficult to convert single-family buildings in certain residential zones, R7, 8, 9, I think requires city council approval. R6, you don't have that option. So planning is making the point that it's just not allowed. R6 allows multifamily, it allows single family, in which case we're building a new single family on a lot that's large enough to accommodate both buildings. And to the extent that conversions even require city council approval, that applies to buildings, not property.
Okay.
You have neighborhood representatives here?
Yes.
I'm Darrell Hirschberger, the neighbor at 842 West 33rd, directly adjacent to this property. So our yards adjoin. This proposed structure would be across the yard from me. And I support the project because I enjoy my neighbor, and I appreciate that he wants to bring parents in and take care of his parents. And I think this is a very appropriate way to take care of his parents. And I also support the project because the existing structure is in bad repair, and this would be a definite improvement in the aesthetics of the neighborhood. And it would also improve the safety of the neighborhood in that having somebody live there to be present in that alley and to see what's happening in the alley would be an improvement. We have I work at a school in the neighborhood, and we have some teachers that live in a house there on the other side of the alley, and we're concerned for their safety, and having some residents in a new house there would, we think, would improve the safety of the neighborhood.
Okay, thank you, sir. Any questions? Mr. Barry, anything else?
You want to say? I'm happy to answer questions, but I don't feel like I need to offer anything.
So just to chime in for a second, just like trying to define our terms, because I think that this is an application that doesn't quite fit anywhere necessarily, obviously, in the code. So we have to kind of make arguments and figure it out. So residential conversions are not allowed in this district. We know that. Multifamily dwellings are allowed by right. So as Mr. Berry said, if they knocked down every structure on the property and built a multifamily, they could do that by right. You just can't convert a single family dwelling to a multifamily dwelling in this district. However, when you look up the definition of single-family dwelling, it does talk about a building. It doesn't consider it to be multiple buildings. From how I read the definition of single-family dwelling and multifamily dwelling, they're talking about one structure, not the lot as a whole and any structures that might be on it, but the one structure. So I can read the definition of multifamily dwelling if that would help, and single family dwelling, but that's just what I wanted to add, is that this is like slightly not directly addressed by the zoning code, but I personally, as your counsel, I don't think it's prohibited.
Wait, I couldn't hear it.
I don't think it's prohibited, is what I'm trying to say. I'm agreeing with you, Al.
I agree. Thank you.
Okay. All right, I think that's it for the presentation, Mr. Barry. resident.
Talking person. Tell me the variance so I can incorporate it. Tell me the right wording of it so I can say it.
Sure. So these are maximum accessory structure height, rear yard setback,
Gotcha.
and interior side yard setback variances.
Okay, so.
Excuse me, just to clarify, the setbacks that we need essentially replicate the setbacks that are not there for the existing garage.
Understood.
Okay. And it's building a smaller, slightly smaller structure than the existing garage.
Okay.
Okay.
So I think that because of the particular physical surroundings, really the shape of the structure and the land involved, and it would be an unnecessary hardship and not a mere inconvenience. The three variances that are being sought should be granted. This is a unique property, and it's definitely not generally applicable to other property in the same zoning district because the houses, it's like two or one single family house, I looked on the map, next to a bunch of row houses, kind of. So I think that if we were to disapprove this variance, it would be the unnecessary hardship and practical difficulty is caused by the code because of the different kinds of properties that are all located in this zoning district, but specifically on the street. And none of this has been created by the intentional action or inaction of the homeowner or the architects that he has employed. So, and it's not based, granting this would not be based on desire to increase the value or income potential. It's based on, for some reason, wanting your parents to live with you. It does not harm of use or enjoyment of other property, as the neighbor has testified to, that he's actually in favor of it. Because of the I guess, unclear and somewhat complicated nature of how the zoning code is written, I believe, and hopefully my colleagues will agree, that it's in harmony with the purpose and intent of the zoning code. It's not precluded by any urban renewal plan, city's comprehensive master plan, or any CHAP-related things, and it does not endanger the public health, safety, or welfare, and it's not in contrary to any public interest. So for those reasons, I think that the three variances requested, the maximum accessory structure height, the rear yard setback, and the interior side yard setback should be granted.
How to vote to approve the request?
I'm a yes, approving for all those reasons stated.
Oh, yes.
Great, thank you.
Okay, we're good.
Thank you.
Thank you, folks.
Thank you very much.
We have one more case on the number of people. I'll call
Yeah, so, yeah, you could call it, and then I can talk a little bit about why you probably don't see anybody.
Okay, case number 2022-245, 4712 Curtis Avenue, Keith Grimes, the appellant, and the request to use the premises as a motor vehicle service and repair major.
So this property, this application is very incomplete, and we wanted to reach out to this applicant, but they did not, it was so incomplete that they didn't provide a phone number or email address to reach out to. We haven't gotten proof of posting, and on top of all of that, this is not an approvable use in this zoning district, so the reason that I kept it on the docket is instead of postponing it, we should probably just deny it since it's not possible to approve it in this zoning district.
Can we deny it without the person here, though?
I mean,
Because if we postpone it indefinitely, then the person still has to reach out back to you to get it back on the docket. But if we deny it and they somehow come up with some miracle thing, they'd have to reapply, and we wouldn't be giving them their due process or whatever.
you could do either one.
Oh, dismiss, not deny? That's I think that way, all the things I just said don't have to, and it doesn't hang around in your caseload.
What you're basically saying is you tried to reach him, he didn't get back to you, you couldn't reach him.
Yeah, he could not be reached. He didn't provide enough information on his application to even connect with him, which I don't really understand why it was forwarded to us at all, but it was. Right, so he doesn't have proof of posting. he cannot have this use in this zoning district. So if the board would like to dismiss it, you can do that. If you would like to postpone it, and we can just keep it and wait for the applicant to reach out to us. And then generally speaking, we dismiss those after about 6 months if we don't hear anything from people. Or you can deny it and say you're not entitled to this use in this district.
Yeah, I'd be inclined to dismiss it. For all those reasons.
I agree.
Great.
I agree.
That sounds unanimous. Thank you. Also, the person who who didn't appear earlier, we never got back to her, or she didn't show up. Did we say that we were going to just wait for her to reach out again? This was,
What, the person who didn't? Yeah.
You never know what would happen to people, so I never want to
Yeah.
like just.
I mean,
I have the notes as postpone and wait to hear from applicant.
Sure.
okay, great.
Yeah.
Great note taking.
That'll work. That concludes the docket?
We are off the record. Thank you, everybody.
Okay, thank you.